Hello, hello. हेलो गाइस टू माय सेकंड स्ट्रीम। कैसे हो सब? आज हम सेकंड चैप्टर कवर करेंगे, इनकॉर्पोरेशन ऑफ कंपनीज एंड मैटर्स इंसिडेंटल देयरटू। Let's first start with the chapter overview. This chapter will discuss in detail the provision contained in chapter 2 of the Companies Act 2013 pertaining to the incorporation of companies and matters incidental thereto. The scope of this chapter is shown in below figure. Incorporation of company and related matters. Formation and incorporation. Minimum members and OPC 1% company section 3 and 3A. Documents required for incorporation section 7. Not for profit company section 8. Important section. Effect of registration section 9. Memorandum and articles. Memorandum of association section 4. Article of association section 5. Act to override MOA AOA section 6. Alteration in memorandum section 13. Alteration in article section 14. Updation of changes to be noted in every copy of MOA AOA section 15. Give copy of MOA AOA to members section 17. Documents. Service section 20. Authentication section 21. Execution section 22. Other provisions. Commencement of business. Section 10A. Registration office. Section 12. Rectify name. Section 16. Convert company. Section 18. Subsidiary can't hold shares in holding. Section 19. Okay. Introduction to Incorporation of Companies and Promoter. Chapter 2 consists of Section 3 to 22 as well as Company Incorporation Rules 2015. A company is sacred legal entity from its member. It has perpetual section, can be incorporated only for lawful purposes. Prior to the incorporation, promotion activities are essential. Promotion signifies a number of business operations familiar to the commercial world by which a company is brought into existence. Persons who undertake promotion activities in order to incorporate the company are generally known as promoters. The Section 2, Subsection 69 of Companies Act 2013, herein after referred to as Act, defines the term promoter. Already mentioned in the chapter 1 of the module, abbreviated there. Promoter means a person who has named as promoter in the prospectus or who is identified as promoter by the company in the annual return or who has control over the affairs of the company directly or indirectly, whether as a shareholder, directors, or otherwise, in accordance with whose advice, directions, or instructions the board of directors of the company is accustomed to act, but shall not include a person who is acting merely in a professional capacity, such as attorney, technical, or functional experts. Students are advised to take note that the above definition serves the purpose to make those a person liable in capacity of promoter for fraud through misstatement, but not highlighting what actually promoters do. Hence, considering the judicial pronounces improves our understanding regarding role of promoter. Promoter is one who undertakes to form a company with reference to a given project and to set it going, and who takes the necessary steps to accomplish that purpose. To be promoter, one need to not necessarily be associated with the initial formation of a company. One who subsequently helps to arrange floating of its capital will equally be regarded as a promoter. Hence, promoter denotes any individual, association, partnership, or a company that takes all necessary steps to incorporate, create, and mold a company and set it going in a fiduciary position. Hmm. Second, formation of company, section 3. In the pre-independence era, company were granted rights by royal charter, but now company is incorporated by either a special act of the legislature or under the Companies Act 2013. Accordingly, an incorporated company may be either chartered company, statutory company, registered company. Section 3 of the Act deals with the registered companies. Forms of companies. The companies are broadly classified into categories shown below in the figure. Definitions of many of these are already covered under chapter 1 of this module. Okay. Kinds of company, incorporated company, unincorporated company, operated company in basis of mode of registration, registered companies, statutory companies, chartered companies, registered companies on the basis of liability, limited by shares, limited by guarantee, limited by shares, public and private company, limited by guarantee with capital, public private, without capital, public private, with capital, unlimited company, public private, without capital, unlimited company, public private. Subsection 1 to section 3 provides that for lawful purpose by subscribing their name to memorandum and complying with the requirement of this act. A public company may be formed by 7 or more persons. A company may be formed by 2 or more persons. One person company as a private company may be formed by one person. Further, subsection 2 to section 3 provides that company formed as specified above may be incorporated either as companies limited by shares or company limited by guarantee or unlimited liability companies. Note, unlimited liability companies may be companies limited by guarantee as well as shares. Specified IFSC public or specified IFSC private company shall be formed only as a company limited by shares. IFSC company means a company licensed to set up business in any international financial services center in India. Example in Gujarat, International Finance City. One person company. Company Act 2013 for the first time allowed the formation of company by just one person with limited liability called one person company. Such a company is described as a private company under section 131C. Further, section 31 along with the rule 3 and 4 of the Companies Incorporation Rules 2014 provides certain provisions specifically applicable in case of one person company listed below. Who can form one person company? Only natural person other than minor who is an Indian citizen and whether resident in India or otherwise shall be eligible to incorporate a one person company. Resident in India means a person who has stayed in India for a period of not less than 120 days during the immediately preceding financial year. OPC can be incorporated or converted into a company under Section 8 of the Act. Further, OPC can't carry out non-banking financial investment activities, including investment in securities of anybody corporates. Indicate name and consent nominee. The memorandum of one person company shall also indicate the name of the natural person other than minor who is an Indian citizen, whether resident in India or otherwise as a nominee, along with his prior written consent and requisite form, who shall, in the event of the subscriber's death or his incapacity to contract, become the member of the company. Note, this provision is to ensure perpetual succession of legal existence of OPC. Okay. The name of such nominated person in the form INC 32 SPICE along with the consent of such nominee obtained in form INC 4 and fee as provided in the company's Registration offices and fees rules 2014 shall be filled with the registrar at the time of incorporation of the company along with its memorandum and articles. A natural person shall not be member of a more than a one-person company at any point of time, and said person shall not be a nominee of more than a one-person company. Sub Rule 2 and Rule 3. Where a natural person being a member in one person company in accordance with the rule 2 rule 3 2 becomes a member in another such company by virtue of his being a nominee in that one person company. Such person shall meet the above specified criteria, can be member of only one OPC within a period of 180 days. Okay. Withdraw or consent by nominee. Such the person nominee may withdraw his consent by giving a notice in writing to such sole member and to the one person company. In this case, the sole member shall nominate another person as nominee within 15 days of the receipt of the notice of withdrawal and shall send an intimation of such nomination in writing to the company along with the written consent of such other person so nominated in the form of declaration in form INC4. Despite a name note, despite a name of such other old nominee and another person, new nominee specified in the memorandum, any such change in the name of person shall not be deemed to be an alteration of memorandum, replacing nominee with another one. The member may change of the name of person nominated by him at any time for any reason, including in case of that incapacity to contract of nominee and nominate another person, a new nominee, after obtaining the prior consent of such another person. Member can do so by giving intimation in writing to the company. This is not specified either in the act or rules whether intimation shall be prior to making change or can be made afterward. But if we consider reasonable construction, the intimation shall be prior intimation. Okay, any such change in the name of the person shall not be deemed to be an alteration of the memorandum Okay, when nominee becomes member, when the role when the where the sole member ceases to be member and nominee become a new member, then such a new member shall nominate within 15 days of becoming member a person new nominee who shall, in the event of his death or his incapacity to contract, become the member of such company. Okay, notice of change to registrar. In all the three cases of change discussed above, withdraw of consent by nominee, replacing nominee with another one, and when nominee become member, the company within 30 days of receipt of notice of withdrawal of consent by nominee, intimation of change of nominee from member or cessation shall file the notice with the registrar of such withdrawal or consent, change or cessation respectively, and intimate the name of such another person, new nominee, in form INC 4, along with the fee as provided in the company's registration offices and fees. Rules 2014 and the written consent of such another person so nominated in the form of a declaration in the form INC 4. Okay. Additional reading. Relaxation available to an OPC include not required to prepare a cash flow statement with the effect of section 240. Okay. Annual return to be furnished under section 92 can be signed by the director and not necessarily a company secretary. Even a abridged annual return may be prescribed. Okay. Further, following the similar line, section 134 provides it would suffice if one director signs the audited financial statements. An abridged form of director report may be prescribed. Holding annual general meeting as required under section 96 is not necessary in case of OPC. Moreover, certain specific provisions related to general meetings and extraordinary general meetings prescribed under section 100 to 111 may not applicable to OPC. Even relaxation is also there in convening board meetings. Section 173 requires an OPC to hold only one meeting of board of directors in each half of a calendar year. Wide notification 137, the OPC are allowed to file financial statements within 6 months from the close of financial year as against 30 days. Okay. Members severely liable in certain cases, i.e. reduction in minimum membership, section 3A. Member may have limited or unlimited liability depending on the nature of company. Generally, the members are jointly liable for the debt of the company, but they shall be severally liable for payment of debts of the company and may be severally sued. Therefore, if any if at any time the number of members of a company is reduced below 7, and 2 in case of public and private companies respectively, and such company carries on business for more than 6 months with a reduced number of members. Every such person who carries on business after those 6 months is cognizant aware of the fact that the business is carried with reduced members. Such members are liable for the payment of all debts of the company contracted during that time after a lapse of 6 months. Okay, we're not doing illustrations, not examples. Incorporation of Company Section 7. Section 7 of the Act provides for the procedure to be followed for incorporation of a company. The steps involved in the process of incorporation are enumerated in the figure shown below. Steps for incorporation. Majority of the steps are covered under Section 7, while some other related to documents such as MOU and AOA governed by Section 4 and 5 respectively. Corresponding procedural aspects are described by Rule 12 and of Rule 12 to 18 of the Companies Incorporation Rules 2014. Fees are notified through Rule 12 of the Companies Registration Office and Fees Rule 2014. Okay, steps for incorporation. First, determine the nature of company, private or public. Second, reservation of name by filing an application. Third, drafting and signing of MOU and AOA. Fourth, submission of MOU and AOA to ROC. Fifth, consent of persons nominated as directors. Sixth, submission of statutory declaration of compliances. Seventh, pay fees and amount of stamp duty. Eighth, obtained certificate of incorporation. Ninth, file declaration about the address of registered office. Note, now it is also required to submit a declaration that all subscribers have paid the value of shares agreed to be taken by him apart from filling of verification of registered office before the commencement of business. Filing of the documents and information with the registrar. Subsection 1. An application for the registration of company shall be filed with the registrar within whose jurisdiction the registered office of the company is proposed to be situated. In SPICE plus form, simplified pro forma for incorporating companies electronically plus INC 32 along with the fee as provided under the company's registration offices and fees Rule 2014 accompanied by the following documents and information. SPICE Plus is an integrated web form offering 10 services by 3 central government ministries and departments: Ministry of Corporate Affairs, Ministry of Labor, and Department of Revenue in the Ministry of Finance, thereby saving as many procedures, time, and cost for starting a business in India. SPICE Plus in SPICE towards years of doing business. Students may refer to facts on SPICE Plus form at MC's website for more details. Okay. The duly signed memorandum of association and articles of association. The memorandum EMOA in the form INC 33 and article EAOA in the form INC 34 of the company so furnished shall be duly signed by all the subscribers to the memorandum in the manner prescribed by the Rule 13 of the Companies Incorporation Rule 2014 as stated below. Each subscriber shall add his name, address, description, and occupation, if any, in the presence of at least one witness who shall attest the signature, shall sign and add his name, address, description of and occupation, if any. Where a subscriber is illiterate, he shall affix his thumb impression or mark which shall be by the person writing for him, who shall place the name of the subscriber against or below the mark and authenticate it by his own signature, and he shall also write against the name of the subscriber the number of shares taken by him. Note: the type, written, or printed particulars of the subscribers and witnesses shall be allowed as if it is written, so long as the append signature or thumb impression. Where the subscriber is a body corporate, the memorandum and articles of association shall be signed by director, officer, or employee of the body corporate duly authorized in this half by resolution of the board of directors. Where the subscriber is a limited liability partnership, it shall be signed by the partner of the limited liability partnership duly authorized by the resolution approved by all the partners of a limited liability partnership. Note: in either case, C or D stated above, the person so authorized shall not at the same time be subscriber to the memorandum and articles of association. where a subscriber to the memorandum is a foreign national residing outside India. His signatures and address on the memorandum and articles of the association and proof of identity shall be notarized by the notary public with the certificate. Further, if such person residing in the country outside the Commonwealth or which is not a party to the Hague Apostille Convention 1961, the certificate of notary public shall be authenticated by a diplomatic or consular officer. Where subscriber to memorandum is a foreign national residing outside India and visited in India and intended to incorporate a company. In such a case, the incorporation shall be allowed if she is having a valid business visa. In case of person is of Indian origin or overseas citizen of India, requirement of business visa shall not be applicable. Okay, practical insight illustration. All right. Declaration of companies by professional and director, manager or secretary of a company. Compliance. Declaration of compliance by professional and director, manager or secretary of a company. A declaration that all the requirements of the act and rules made thereunder is in respect of registration and matters precedent or incidental thereto have been compiled with shall be filed in the form INC 8 by an advocate, a chartered accountant, cost accountant or company secretary. In practice, who is engaged in formation of a company and a person named in the articles as a director, manager or secretary of the company. Declaration by subscribers to the memorandum and persons named as the first directors. A declaration in form C 9 from each of the subscribers to the memorandum and from persons named as the first directors, if any, in the articles stating that all the documents filled with the registrar for registration of company contain information that is correct and complete, true to the best of his knowledge and belief. He is not convicted of any offence in the connection with the promotion, formation or management of any company, or he has not been found guilty of fraud or misfeasance of any research breach of duty to any company under this act or any previous company law during the last 5 years. Address for correspondence. The address for correspondence is registered offices established. Particulars of persons named as the first directors. The particulars, i.e., name, including surname or family name, director, identification number, DIN, residential address, nationality, and such other particulars, including proof of identity of each person mentioned in the articles as first director of a company and his interest in the other firms or bodies incorporated, along with his consent form number DIR2 to act as the director of a company shall be filed in form number 2 DIR 12 along with the fee as provided in the company's registered offices fees rule 1014. Particulars of subscribers to the memorandum. The following particulars of every subscriber to the memorandum shall be filled: name, including surname or family name, recent photographed, affixed, mother's name, nationality, proof of nationality in case of the subscriber is a foreign national, date and place of birth, district and state, educational qualification and occupation, permanent account number, email ID and phone number of subscriber, permanent residential address and also permanent present address, residential proof such as bank statement, electric bill, telephone, mobile bill, providing that the bank statement, electric bill, telephone or mobile bills shall not be more than 2 months old. Proof of identity. For Indian nationals, voter's identity card, passport copy, driving license copy, unique identification number (UIN), and for foreign national and non-residential Indians, passport. If the subscriber is already a director or promoter, the particulars relating to the name of the company, corporate identity number, whether interested as a director or promoter. Where the subscriber to the memorandum is a body corporate, then the following particulars shall be filled with the registrar: the name of the body corporate and corporate entity number of the company or registration number of body corporate if any, GLN if any, the registered office address or principal place of business, email ID if the body corporate is company, certified true copy of the board resolution specifying inter alia the authorization to the subscribe to the MOA. If the body corporate is a limited liability partnership or partnership firm, certified true copy of the resolution agreed to by all the partners specifying inter alia to the authorization to subscribe to the MOA. In case of foreign bodies corporate, the details relating to the copy of certificate of incorporation of foreign body corporate and other registered office address as per the Rule 12 of the Companies Incorporation Rules 2014. In case of any of the any of the objects of a company requires registration or approval from sectoral regulators such as RBI and SEBI, then such a registration or approval shall be obtained by proposed company before pursuing such objects, and a declaration in this behalf shall be submitted at the stage of incorporation. In case of a company being incorporated as a NIDI, the declaration by the central government under Section 1406 of the Act shall be obtained by the NIDI force before commencing the business, and a declaration in his behalf shall be submitted at the stage of incorporation by the company. Issue of certificate of incorporation on registration. The registrar, on the basis of documents and information filed, shall register all the documents and information in the register and issue a certificate of incorporation in the form INC 11 to the effect that the proposed company is incorporated under the Act. Certificate of incorporation shall mention permanent account number of the company where it is issued by the Income Tax Department. Okay. This is a certificate of incorporation. Okay. Allotment of corporate identity number CIN on and from the date mentioned in the certificate of incorporation, the registrar shall allot to the company a corporate identity number which shall be distinct identity for the company and which shall also be included in the certificate of the incorporation. CIN is a 21 alphanumeric digit based unique identification number comprising data sections elements that reveals the basic aspect about the company. Okay. Decode the CIN. Okay, maintenance of company copies of all documents and information. The company shall maintain and preserve copies of all documents and information as originally filed at its registered office till its dissolution under this Act. Furnishing of false or incorrect information or suppression of material fact at the time of incorporation, i.e., during incorporation process. If any person furnishes any false or incorrect particulars of any information or suppresses any material information of which he is aware in any of the documents filed with the registrar in the relation to the registration of a company, he shall be liable for action for fraud under section 447. Note: provision of 447 explained in detail in book chapter 3 prospectus and allotment of security. Okay, chapter 3 में explain हुए. Companies already incorporated by the furnishing any false or incorrect information or representation or by suppressing any material fact, i.e., post incorporation, where at any time after the incorporation of company it is proved that the company has gotten incorporated by furnishing any false or incorrect information or representation or by suppressing any material fact or information in any of the documents or declaration filed or made for incorporating such company or by any fraudulent action. Then the promoters, the persons named as the first directors of company, and the persons making a declaration under this section shall be liable for action for fraud under section 447. Order of the tribunal. Where a company has been got incorporated by furnishing false or incorrect information or representation or by suppressing any material fact or information in any of the documents or declaration filed or made for incorporating such company or by any fraudulent action, then the tribunal NCLT on being satisfied that the situation so warrants in response to an applicable made to it may pass order as it may deem fit, including a regulation of the management of the company, including charges, if any, in its memorandum and articles in public interest or in the interest of the company and its members and creditors, or the director or direct the debt liability of the members shall be unlimited, or direct removal of the name of the company from the register of companies, or winding up of a company, or provided that before making any such order, the company shall be given a reasonable opportunity of being heard in the matter, and the tribunal shall take into consideration the transaction entered into by the company, including the obligations, if any, contracted or payment of any liability. Tribunals means the National Company Law Tribunal (NCLT), constituted on 1st June 2016 under Section 408 of the Companies Act 2013. The NCLT, wait a minute, guys. Just a minute. Okay, we are back. The NCLT is a quasi-judicial body in India that adjudicates issues relating to the companies in India. Example, the certificate of incorporation is not inclusive proof with respect to the legality of the objects of the company mentioned in the objects clause of the memorandum of association. As such, if a company has been registered whose objects are legal, the incorporation does not validate the illegal objects. In such a case, the only remedy available is to wind up the company. Okay? Formation of companies with the charitable objects, etc. Section 8. The underlying purpose of formation of company is not always making profit through operating economic activities. It may have charitable or social objects. To illustrate, Prem Foundation CIN number and Azam Lalji Foundation CIN number. Students are advised to take note that the data section of the both the CIN numbers comprises of NPL, which signify non-for-profit license company. CIN, NPL, NPL. All right. Such companies are licensed by central government in Section 8 of the Companies Act 2013. Relevant provision of the Section 8 and applicable rules thereto as described below. Note the power of central government under Section 8 delegated to ROCs to the extent and for the purpose of subsection 1, clause 2 to the subsection 4, except for alteration of memorandum in case of conversion into other kind of company, and subsection 5. Regional directors to the extent and for purpose of clause 1 to subsection 4 for the alteration of memorandum in case of conversion into the other kind of company, and subsection 6 who can issue and get the license under section 8(1). As per section 8, the central government ROC in its behalf may grant such a license if it is proved to the satisfaction that a person or an association of persons proposed to be registered under this act as a limited company, has in its objects the promotion of commerce, art, science, sports, education, research, social welfare, religion, charity, protection of environment, or any such other object, intends to apply its profits, if any, or other income in promoting its objects, and intends to prohibit payment of any dividend to its members. Note: the use of word person appears to allow even a single person to form a company for the objects specified. However, as discussed earlier under heading OPC of this chapter, that Rule 35 of the Companies Incorporation Rules 2014 prohibits the OPC to be incorporated or converted into a company under Section 8. Okay. Likewise, as per Section 285, a small company cannot be incorporated or converted into a Section 8 company. A firm may be a member of a company registered under Section 8, despite members' liability is limited. The words limited or private limited shall not be added to its name, but on registration, the company shall enjoy the same privileges and objects as of a limited company. Okay. License issued may be on such conditions as central government RCs deem fit. Alright, guys, we will take a 2 minute break now. Okay, now we back. Let's start. Registration of company using license. After granting license, an application shall be made to the registrar under Section 8(1) itself for registration of company in the manner specified in the Rule 19 of the Companies Incorporation Rule 2014. Application for registration. A person or an association of persons desirous of incorporating a company with the limited liability under Section 8A shall make an application to the registrar in Form Spice Plus, along with the fees as provided in the company's registration offices and fees Rule 2014, supporting documents along with the application. The application furnished as specified above shall be accompanied by the following documents: the memorandum and articles of association of the proposed company, declaration by an advocate, a chartered accountant, a cost accountant, or company secretary in the practice that the memorandum and articles of association have been drawn up in conformity with the provisions of the Section 8 and rules made thereunder, and that all the requirements of the Act and the rules made thereunder relating to the registration of the company under Section 8 and the matters incidental or supplemental thereto have been complied with. An estimate of the future annual income and expenditure of a company for next 3 years, specifying the resources of income and objects of the expenditure. Declaration made by each of the persons making the application. Alteration of a memorandum and as articles requires prior permission of government. A company registered under this section requires prior permission from central government, power delegated to the regional directors for alteration of its memorandum, and central government power delegated to ROCs for alteration of its articles. Conversion into any other of a company. A company registered under this section may convert itself into company of any other kind if only after complying with such conditions as may be prescribed in the Rule 21 of the Companies Incorporation Rule 2014 as prescribed below. A company shall pass a special resolution at a general meeting for approving such conversion. An explanatory note statement to notice of such general meeting must set out the details on reason of such conversion. The company shall file an application in Form INC 18 with the regional director with the fee along with the certified true copy of special resolution and a copy of a notice convening the meeting, including the explanatory statement for approval for conversion. Also attach the proof of serving of notice served by a registered post or hand delivery to the Chief Commissioner of Income Tax having jurisdiction over the company. Income tax officer who has jurisdiction over the company, the charity commissioner, the chief secretary of the state in which the registered office of the company is situated, any organization or department of the central government or state government of other authority under whose jurisdiction the company has been operating. If any of these authorities wish to make any representation to the regional director, it shall do so within 60 days of the receipt of notice after giving an opportunity to the company. An intimation along with the copy of application with the annexures as filed in the form INC 18 with the regional director shall also go to the registrar through MCA system. The company shall, within a week from the date of submitting the application to the regional director, publish a notice at its own expense, and a copy of notice as published shall be sent forth with to the regional director, and the shared notice shall be formed INC 19 and shall be published at least once in a vernacular newspaper in the principal vernacular language of the district in which the registered office of the company is situated, and having a wide circulation in that district, and at least once in English language in an English newspaper having a wide circulation in that district, and on the website of a company if any, and as may be notified or directed by the central government. The company should have filed its financial statements and annual returns up to the financial year preceding the submission of the application to the regional director, and all other returns required to be filed under the Act up to the date of submitting the application to the regional director. Note: in the event of application is made after the expiry of 3 months from the date of preceding financial year to which the financial statement has been filed, a statement of the financial position duly certified by the chartered accountant made up to the date not preceding 30 days of filing the application shall be attached. On the receipt of the application and on being satisfied, the regional director shall issue an order approving the conversion of the company into a company of any kind subject to the such terms and conditions as may be imposed in the facts and circumstances of the each case. Before imposing the conditions or rejecting the application, the company shall be given a reasonable opportunity of being heard by the regional director. On receipt of approval of the regional director, the company shall convene a general meeting of its members to pass a special resolution for amending its memorandum of association and article of association, and the company shall thereafter file these with the registrar with the declaration to other conditions, if any, imposed by regional director. On receipt of documents referred above, the registrar shall register the documents and issue the fresh certificate of incorporation. Revocation of license. The central government power delegated to regional director may by order revoke the license of the company where the company contravenes any of the requirements or conditions of the subject or subject to which the license is issued, or the effects of the company are conducted fraudulently or in violation of the objects of the company or prejudicial to public interest. Note: on revocation, the registrar shall put limited or private limited against the company's name in register. For such revocation, a written notice must be served on such company, and an opportunity to be heard in the matter shall be given. Where a license is revoked and the central government is satisfied that it is essential in the public interest, then after giving a reasonable opportunity of being heard by the order, it may direct that the company may wound up under this act excess assets on the winding up or dissolution after the satisfaction of its debts and liabilities may be transferred to another company under this section and having similar objects and subject to such conditions as the tribunal may impose, or may be sold and proceeds thereof credited to the insolvency and bankruptcy fund formed under the section 224 of the Insolvency and Bankruptcy Code 2016. Company being amalgamated with another company registered under this section and having similar objects, the central government empowered with the overriding special effects to provide the said amalgamation to form single entity with such a constitution, properties, powers, rights, interest, authorities, and privileges with such liabilities, duties, and obligations as may be specified in the order. Penalty punishment in contravention. Penalty for offences under section 8 are summarized below. Okay. Offence. Penalty. Offence: company makes any default in complying with any of the requirements laid down in the section. Penalty: company shall be punishable with the fine verifying from 10 lakh rupees to 1 crore rupees. Directors and every officer of the company who is in default shall be punishable with the fine varying from 25,000 rupees to 25 lakh rupees. Where the affairs of the company were conducted fraudulently, penalty: every officer in the default shall be liable for action under section 447. Summary of subsection 6 to 11 of section 8. Contravention: license revoked, punishment. Contravention: license revoked, expression Ltd or private or else limited added to the name Dividing up surplus assets transfer to amalgamate with the sectioned company with similar objectives. Sectioned company with similar objectives, insolvency and bankruptcy code. Punishment: company with 10 lakh to 1 crore, directors and officers with the 25,000 25 lakhs code under section 447. Additional reading. Okay. Relaxation available to sectioned company include can call its general meeting by giving a clear 14 days notice and instead of 21 days. Requirement of a minimum number of directors, independent directors, etc. does not apply. Need not constitute nomination and remuneration committee and shareholders relationship committee. Okay. Effect of institution. How long is this? Okay. This will be the last topic for today. Effect of registration, section 9. Section 9, last topic of today. Section 9 of the Act provides for the effect of registration of a company. It states from the date of incorporation specified in the certificate of incorporation, the subscribers to the memorandum and all other persons who may become members of such company shall be a body corporate by the name as combined in the memorandum. Thereafter, after such body corporate by the said name shall be capable of exercising all the functions of an incorporated company under this act and having perpetual succession, power to acquire, hold, and dispose of property, both movable and immovable, tangible and intangible, to contract and to sue and be sued. Okay, summary of section 9. Subscribers to the memorandum and all the other persons who may from time to time become members of the company. Registration certificate of incorporation granted from the date of incorporation specified in the certificate of incorporation become body corporate by the name specified in the registration memorandum under said name, exercising all the function of an incorporated company, power to acquire, hold and dispose of property, movable and immovable property, tangible and intangible property, to construct and to sue and be sued, having perpetual succession. Alright, this will be it today. आज इन तक करेंगे, कल ड्राफ्ट करेंगे इसका, मेमोरेंडम ऑफ एसोसिएशन से कल स्टार्ट करेंगे और पूरा चैप्टर कंप्लीट कर देंगे. So I hope you like this. अगर आपको अच्छा लगा प्लीज़ हमारे चैनल को सब्सक्राइब करना. मेरा चैनल है, हम इसमें रोज मैं इसमें इनकम टैक्स का भी सोच रहा हूँ लेके आऊँगा, लेके आएंगे ही जरूर, और ऑडिट का भी, खासकर ऑडिट का भी चाहिए अपनों को, उसकी भी रीडिंग साथ में करेंगे. अगर आपको ऐसा कंटेंट अच्छा लगा तो प्लीज़ वीडियो को लाइक करना और चैनल को सब्सक्राइब करना.